Jonathan Pollard in downtown Fort Lauderdale, and I'm going to talk today about non-compete agreements and specifically about how you can respond to a cease and desist letter. In non-compete disputes, cease and desist letters represent the first shot fired. This is always how a non-compete battle begins. You work for a company, you leave that company, you go to work for a competitor. A few weeks later, you receive a letter in the mail or via email from a law firm representing your old employer. It tells you you have a non-compete agreement, that agreement is attached, you have breached that agreement, and we are going to sue you unless you stop. When you're faced with that situation, when you're faced with a cease and desist letter, you have three basic options. There may be other options, but these are the three basic ones. I'm going to go through each of these and give you some of the pros and cons for each of these approaches. Option one, you can do nothing, just sit tight, see what happens. Option two, you can write a letter back, basically rebutting what they've laid out in their cease and desist letter. And option three, you can sue first and seek a declaratory judgment. But let's take option one. Option one, sit tight, do nothing, and see what happens. Whether or not this is a wise course of action to simply do nothing and see what happens really depends on the specific facts of your case. If you are a low-level employee, or rather were a low-level employee at the previous company, there is a chance that they're simply firing off a cease and desist letter to scare you. There is a chance that they really will not go through the trouble and expense of filing a lawsuit and litigating the case, particularly, to be candid, if they know that you do not have the money to pay a judgment, to settle, to satisfy a judgment. If you were a low-level employee, they may simply say, we're going to try and scare them with the cease and desist letter, see what mileage we get out of that, and then we're going to go away. That's a possibility. But many of the clients I represent, they are not low-level employees. They are higher-level employees. They are vice presidents, presidents, management, directors. These are people who are likely to know corporate secrets, inside information, people who have valuable contacts with clients. These are situations in which if you sit tight, if you wait and see what happens, you will most likely be facing a lawsuit. So option one, this is always on the table. You can simply sit tight, wait and see what happens. If you choose this course of action, you have to be prepared to accept the consequences. Some people at first blush think this is the cheapest option because they don't have to shell out any money up front on legal fees. They're not paying an attorney, they're not doing anything, they're simply waiting to see what happens. That is a short-sighted view of costs. If you have gone to a competitor and you have any type of higher level position, there is a real risk that the filing of a lawsuit over your non-compete agreement could jeopardize your relationship with your new company. It could jeopardize your employment. It could jeopardize your new job. It might scuttle deals that you're working on. It might injure your reputation in the industry. So there are costs here. The costs are not just in terms of attorney's fees. There are also costs in terms of dealing with litigation, dealing with fallout in your employment relationships, dealing with deals being scuttled. You have to take all of these things into account and realize that simply doing nothing is not necessarily a cost-free option, but doing nothing is indeed the first option on the table. The second option, and one that I often recommend clients to pursue, is to write a letter back in response to the cease and desist letter. This, again, depends on the facts and circumstances of your case. If you are in a solid to strong position on the case law and on the facts, then you can write a letter back in response to their cease and desist, and you can say, I will not cease and desist, I am not violating my agreement, or the agreement is unenforceable. I often recommend this course of action for a number of reasons. In many instances, a former employer fires off a cease and desist letter, or their counsel fires off a cease and desist letter, without really considering the merits of the case. They do this for reasons tied up with emotions, personal vendettas, things of this sort, and they haven't really taken the time to sit down, look at the law, understand the relevant cases, and understand whether or not the non-compete will be enforced. If you can respond with a letter saying, I am in receipt of your cease and desist letter. You are wrong for the following reasons. I am not going to stop working for this new company because your non-compete agreement is unenforceable. If you can do that, write a compelling 2 or 3 page letter back, that will, in many instances, resolve the entire situation. Some people think that sounds fantastic or too good to be true, but in my experience, a letter in response to a cease and desist letter is often the most effective course of action. You point out the holes in their case, you point out the flaws in their position, and from a corporate counsel perspective, from a business judgment perspective, nobody wants to get involved in a losing non-compete case. If you are a company and your former employer has a not former employee rather has a non-compete agreement, you do not want to pursue litigation unless you know you have the upper hand, particularly when non-compete agreements as written, and in Florida the statute as written, contain provisions awarding the winning party attorney's fees. So from a business perspective, you do not want to waste the time, you do not want to waste the money on non-compete litigation unless you know you are in a strong position. And if you are entertaining the prospect of non-compete litigation, you fire off a cease and desist letter, and in response, you receive really just an absolute, a piece of work that says you're wrong and you're going to lose, and it points out the reasons, and it's correct, and it's compelling, and it's legally accurate. That's going to make you think twice. And in that instance, many companies, many corporate counsel will simply back down. You will hear nothing else about it. The third option and the most aggressive option is to sue first and seek a declaratory judgment. This is only an option you can pursue if you are in a particularly strong position on the facts and on the law. To give you an example, you've left a company, you're going to work for a competitor, you are in a completely different role. So you went from being in some type of technical position to being in some type of sales position. You're not going to use any of the information from your old company. Indeed, it's unclear whether you even had any information from your old company. You are not soliciting customers. You are not soliciting clients. You're in a strong position. You know you can win. The law is on your side. If that's the case, then in some instances, there is a great deal of utility to suing first. Again, you only do that if you're in a strong position. But sometimes, if you have a new job, you're at a new company, you're in a high-level position, your new position is very important. It's very important within your new company. They don't want to get bogged down in non-compete litigation, and you want to wrap this up as quickly as possible. Sometimes, in that instance, the most advisable course of action is to affirmatively sue first, because that says to your former employer that you're not playing games, you're not messing around, you are in a strong position on the law, so much so that you are willing to fire the first shot in the courtroom. You are willing to seek an injunction, literally you're willing to seek a declaratory judgment holding that the non-compete agreement is unenforceable. Many times in that instance, if you're in a strong position and you sue first, the former company is simply going to come to the table and they're going to wrap it up neatly. They're going to agree that the non-compete agreement is unenforceable, and they're going to agree to pay your attorney's fees. So those are your 3 options. You can sit tight, you can do nothing, you can send a letter back in response pointing out the flaws in their position, or if you are in a particularly strong spot, you can sue first and seek a declaratory judgment. Jonathan Pollard, non-compete and antitrust lawyer in Fort Lauderdale, Florida.